Hello, and welcome to PEI's webinar titled COVID-19, Protecting Employee Privacy in Your Business. I am Melinda Whitney, Director of Operations at PEI. Today's webinar features Rick Long of PEI, as well as two employment and privacy law attorneys with the law firm Arnold Porter, who are experts on data privacy in labor and employment. Before I hand it over to Rick to begin, I'd like to cover a few housekeeping items. We received a number of questions in advance, and the panelists will try to address as many as they can during today's session. If you'd like to ask a question during the webinar, use the Q&A button on the bottom of your screen. Again, the panelists will try to address as many as they can, but they may not be able to get to all of them. Today's session is being recorded and will be available shortly on PEI's website in the Coronavirus Resource Center at www.pei.org. Now I'd like to introduce the moderator of today's webinar, Rick Long, PEI's Executive Vice President and General Counsel.
Thank you, Melinda. Good morning, everyone, or good afternoon to those of you who are on the East Coast. At last count, we had more than 200 PEI members who are participating in this session, and we want to thank each and every one of you for taking the time out of the day to be with us. During these challenging times, PEI is doing as much as we can to help our members with the business side of your business. Today, I'm delighted to welcome two experts who will help us understand how to protect the privacy of your employees who may be infected with COVID-19 while still guarding the interests of other employees and the interests of the business itself. Josh Alloy and Nancy Perkins both practice in the Washington, D.C. office of the Arnold Porter law firm. Josh earned his JD from the University of Pennsylvania and works in all aspects of labor and employment law. Nancy is a graduate of the Harvard Law School and focuses her practice on regulatory compliance and emerging policy issues, including data privacy and security. Josh and Nancy helped co-author a recent paper called Employee Privacy with Respect to COVID-19. And Josh is one of the co-authors on a brand new paper called Returning Employees to Work: What Should U.S. Employers Think About? Shortly after this session concludes, I'm happy to announce that we'll be sharing links to both of these papers on PEI's website so you can do a deeper dive on these important subjects. Josh and Nancy, thanks so much for joining us today and sharing your expertise. As Melinda mentioned, a lot of questions have already been submitted, so let's get started. Let's begin with the very big picture. Nancy, it seems like a pretty straightforward matter in one sense. Employers should do everything they can to protect the health of their employees, customers, and associates. How do privacy concerns make it not that simple?
Well, that's a good question. First of all, thank you so much for including us. We're really honored to be part of this, and we do hope that our guidance will be helpful to your members. So why do privacy issues not make that so simple? Well, yes, it is definitely a very high issue to protect the health and safety of your employees, and you want to do everything you possibly can to do that. But in this crisis situation where what's happening is infection from one individual to another individual, one might think that the best thing to do is to tell everyone if someone's infected. And as I think all of us can imagine, the disclosure of that to others about oneself might be objectionable from a privacy perspective. And where the law comes into it is in favor of protecting the individual's privacy as a general matter. And I will say, although employers are separate from their employee health plans, I would guess that most of your members are familiar with, or at least somewhat familiar with, the rules governing their health plans, which could be relevant in this kind of situation, because if an employee were tested for COVID and that test was covered by the health plan, the employee health plan would have information that the individual had been tested. And that information is protected under the HIPAA privacy rule, which is very, very strict about uses and disclosures without an individual's consent. Employment law is less specific as to privacy in that regard, but the principles, I think, of fundamentally, the basic privacy principle is that without consent of the individual to whom personal information pertains, you need to be looking for a justifiable reason for use or disclosure of that information, or you may be at risk of some type of claim. So without getting specific about specific privacy law things, that's really why it's not so simple, because it is too complicated to describe what might apply and what not in a certain circumstance.
Right, and we'll drill down into some very specific questions in a few minutes, and maybe it will help that. But from what you said, part of me wants to think that protecting all of your employees should trump an individual's privacy interests, but it sounds like you're saying that's not necessarily the case.
Well, that's a really interesting question, because it depends really on what legislators and regulators have decided is the public policy purpose that trumps the other purpose or the other interest. And so just going back to the HIPAA privacy rule, because it's very specific in these ways, the fundamental rule there is you need an authorization, in fact, a written authorization from the individual in order to use or disclose their personal health information. Again, that only applies to employers' health plans, not to the employers themselves, but I'm just using an example. But then there are many, many exceptions to that requirement to get the authorization, all of which, really, I would say all of which, are based on a public policy reason that was deemed by the regulators to trump the privacy interest. And so, for example, disclosures to public health authorities of certain conditions is appropriate, but that's a disclosure to an agency, public health, governmental agency. Disclosures of a condition that might indicate domestic violence to a state agency that deals with domestic violence, that might be permissible. Disclosures to law enforcement, but all of them are carefully thought out exceptions that have a public policy purpose. So essentially, your question is, yes, if we are deciding this is the public policy purpose and we're the legislators and regulators, but if we're not making the law, we have to pay attention to what somebody else decided was the public policy purpose that should trump. So that's where the law comes into play.
Very good.
And if I can jump in, I mean, we'll see, sure. And I think we're going to talk about a little throughout where some of these safety and health interests do end up trumping individuals' privacy rights. And so I'm thinking in particular, normally, employers generally know you're not supposed to ask employees about a medical condition or a medical issue that they may have unless they come to you, and then it's within certain prescribed parameters that you're really only allowed to delve into. But we've seen that some of those privacy concerns have been lessened here where there is this pandemic. And so being able to ask employees if they are infected, or requiring employees to have their temperatures taken, which is an invasive medical question or procedure in some ways. All of these things have sort of given way in the face of this pandemic. And as I said, I think we're going to talk about these in response to more specific questions. But so, public safety and the safety of employees is trumping privacy in some ways and just not in all ways.
Yeah, and I'll just add one thing on that too. Under the HIPAA privacy rule, the Department of Health and Human Services, which is the responsible agency, has also relaxed a lot of those rules in response to this pandemic. And so, because it was understood that would constrain the overall public health goal. And so a lot of that, areas where an individual would have had rights of objection or whatever have been relaxed, and they're not enforcing those parts of the rule. So we are in a very special circumstance.
That's for sure, isn't it? All right, this is another kind of general question before we go more specific. Very few of PEI's 1,500 members have so far yet had a confirmed positive test or even a known exposure. So that's very good news. But what steps would you encourage companies to do now that might protect them later on? Nancy, Josh, whichever one of you wants to jump in on that.
Well, I'm sure Josh has something, so I'll just quickly say, I think that having transparent guidelines about what your policies are is really important for, and I would guess this is so from the employer law privacy, the employment law perspective as well, but for your employees to understand your objectives and to have a clear sense of what your guidelines are. And the prevention is probably involves getting as much information as you can in advance of infection, which doesn't necessarily mean you disclose if you hear from a particular employee that if you disclose anything about it as to that particular employee, but you do want to have policies where you're in one way or another preventing the infection from spreading. So the infection probably you would have and I'll let Josh address this, but you have a stay-at-home individual employment stay-at-home rule, and then you're not needing to disclose the employee's identity necessarily in relation to the virus. So John, go ahead, Josh.
Yeah, and I'm not sure how broad we want to go here, but so assuming that you're operating in a city and state where you're allowed to open your facilities and employees can come back, right? So that's question one. Are you allowed to reopen, or have you been deemed an essential business? Two, has your state issued any guidelines on reopening? Some states and localities have begun to issue some guidelines, and the CDC has also issued some guidelines on how to prepare your workplace to make it safer. And then I'll sort of touch on some kind of broad topics here, and we can always go into them in more detail if we want now or later. I mean, one, clean and sanitize the workplace. Even if you don't have any reported incidents or exposure, it's not a bad idea if you're going to be reopening, or even if you've been operating, to have done a sort of deep clean and sanitization of the workplace. And all of this, I think, I agree with Nancy, it falls within the rubric of it's a good idea to have a written policy or plan that you can distribute to employees to let them know that you are taking this seriously, and so that you can lay out all of the steps that you as a business are taking to protect your employees, because ultimately that's the employee's primary concern. Are they safe, and is the employer taking this seriously, and is it taking our health and safety seriously? So clean and sanitize the workplace. I think that a lot of companies are implementing new social distancing rules for the workplace. So one is increased, a lot of businesses have already been teleworking for a couple months, but continuing to allow employees and encouraging employees to telework as much as possible will reduce the number, anything you can do to reduce the number of employees that are coming into the workplace on any given day. So maximize teleworking. Staggering work schedules is another thing. So rather than have 100% of the workforce return to work, you have 50% of the workforce return on, for 20 hours a week, and the other 50%, a different time schedule. Limiting or prohibiting travel, as well as limiting or prohibiting meetings. So a lot of companies have, for the time being, prohibited all in-person meetings and are continuing to do Zoom meetings even inside the office. And I've also seen companies implement these types of measures in phases. And so some may start, this is particularly if you've been out of work or been fully teleworking, but sort of a phase one, which is a gradual reopening of the workplace, and then over time, a lessening of some of these restrictions, restricting visitors to the workplace if at all possible, rearranging the workplace so that desks and cubicles are, more than 6 feet apart, ideally. If there are cubicles and not individual offices, putting up partitions or shields to try to protect employees, closing down common areas such as pantries, requiring employees to practice good hygiene. I think this is sort of an obvious one that has been out there for months from the very beginning, but the CDC's got posters that you can put up instructing employees on how to wash their hands and reminding them to regularly wash their hands and avoid touching their face. You can stock the office with personal protective equipment, so masks, gloves, sanitizers, lots of garbage receptacles. See if your bathrooms are touch-free. I understand a lot of these measures, may be costly, and so you can't do everything. And this is not a laundry list of things you have to do, but there are steps that I'm seeing employers take around the country. Requiring employees to wear masks wherever possible. This may be job dependent and business dependent on whether employees can do their jobs with masks or whether it's even necessary if you're already limiting interaction between individuals, but certainly requiring face coverings in all common areas. Screening measures. So I think we're going to talk a little bit about this because this is where we start to intersect with privacy, but implementing screening measures for not just employees, but any visitor, anyone coming into the facility. So temperature checks are optional. Some companies are instituting mandatory temperature checks before anyone can enter the building. Where you set the limit and basically sending anyone whose temperature registers above a certain level, whether that's 100.3 or I've seen some businesses set it lower at 100, but anyone with an elevated temperature is not allowed to enter. You can also have employees self-certify if it's just not realistic to have either a medical professional or a management physically checking everyone's temperature on their way in. You can have employees self-certify that they've taken their own temperature in the morning before coming in and that they have not registered a temperature above a certain level. Screening questions, whether this is sort of you've set up a station at the front of the building and you ask everyone before they come in, or you again have employees sort of self-certify or sign in every morning with a certification, but that they've been symptom-free for at least 3 days. Ideally, they haven't had any symptoms within the last 14 days, that they have no fever and haven't had a fever in 72 hours, that they haven't been exposed to anyone with a confirmed case of COVID in the last 2 weeks. All of these types of questions can be asked of employees, and they certainly do invade on employees' privacy. And I think that's okay right now. Where I think you do need to be careful is if you as an employer are keeping records of employees' medical history or their temperatures, that you then fall into record keeping requirements under various employment and privacy laws. And depending on the state you're in, you may need some kind of, you may need to be giving sort of notice to employees that you're going to be asking these questions or taking temperatures. I generally don't recommend keeping records of this. It's just a yes, no. Either you pass the test and you can go in, or you don't pass and you got to go home. If an employee has been out of work because they're sick or because they've been diagnosed with COVID or suspect they have COVID, requiring medical certification before they can return to work is certainly a best practice. I think that depending on where you are located, it is challenging for individuals to obtain medical certification in all cases, even where they've tested positive. Getting a certification or getting the multiple negative tests is not always possible just because of the local health authorities are overwhelmed right now. And so if you can't get a certification from an employee, despite the employee's best efforts, having that employee certify that they've been symptom-free for, if they've tested positive, that they've been symptom-free for 2 weeks, that they've quarantined, that they haven't had a fever in at least 3 days, all of those could take the place of a medical certification to allow someone back to work. So I know I just threw a whole lot at you, so feel free to follow up wherever you like.
It's really good stuff, though, and I like the focus that some of these things may not be practical in a given case. You're not necessarily going to be able to go in and rebuild all of your bathrooms so everything is touchless. That may not be a practical solution, but to do what you can is certainly the way to go. Now, this question flows out of something you did talk about, and it's it is a privacy question. Most of PEI's members are considered essential businesses, so they have been working throughout this ordeal. If an employee calls in sick and just says, "I'm not feeling well today," can the employer ask if they are experiencing COVID-19 type symptoms?
I think, Josh, that's more for you, really.
Is that for me? Sure. The answer is yes. You as an employer are allowed to ask employees, whether they've called in sick or not, you are allowed to ask employees if they are experiencing any symptoms. In fact, you are allowed to require employees, and I suggest that you should, require employees to report to you if they experience symptoms of COVID or if they test positive for COVID. And certainly if an employee calls in because they are sick, you can ask them whether they are experiencing symptoms. And the reason is not because you want to get into the nitty-gritty of what their symptoms are or their medical history. It's because if that person has been in your physical office or facility within the last week, they may have inadvertently exposed others to the virus, or they may have been asymptomatic for some period of time, and we still don't have any idea how long, what the incubation period is, or how long it takes until that people can be exposing others. And so, you as an employer, have a right to know whether someone's experiencing symptoms or has tested positive, so that you can then take appropriate measures to either clean the workplace and also to sort of do contact tracing on your own. And so that's another thing that you are allowed to do. You can ask an employee who reports in that they've tested positive. You can say, where were you over the last, when did you first start experiencing symptoms, and then, go back 3 days to a week. Who have you been in contact with? What areas were you in, any common areas? And ask that employee, if they can, to sort of try to recall who they've been in contact with, so that you can then inform those other employees that someone, identity unknown, has tested positive for COVID or may test positive for, you believe is experiencing symptoms and may be positive, and that person was in contact with you within the last week, so that those other employees can now take appropriate measures to monitor themselves and to try to, as soon as they start to experience anything, if they do, to immediately self-isolate themselves. But what you shouldn't do, and Nancy can speak to this as well, is disclose the identity of the employee who is experiencing symptoms or who has tested positive.
Okay, that actually, and I'll throw this to Nancy then, because that was the next question I was going to ask. In a fairly small company, once the word is going to spread, there are going to be rumors circulating that someone is either symptomatic or has been confirmed. When employees come to their supervisors to ask for a confirmation of, is so-and-so sick, does he or she have COVID, what can or should the supervisor say? How should they respond to that?
That's a tough question. I mean, basically, they should never disclose the employee, the name of the employee who's tested positive unless that employee has said that's fine to do. And there may be circumstances in which an employee would say that is fine to do. But I'll address otherwise if they can't. And I would say that if it is a small environment, a small work environment, people may make suppositions, and there's not much you can do to prevent that. But you can limit even short of the identity, you can also limit the information you provide. So for example, Arnold Porter is in a very large office building. We have proximate offices, obviously. So there are some more proximate than others. And you would, in our circumstance, if someone had reported positive, you would be better off saying that, or legally you want to say that, you were on the same floor as someone who tested positive. That would be okay because we have a significant number of employees on the same floor. You would not want to say that person is in your cluster or, works next to you. Be pretty obvious. And so you need to be careful, not only about the individual's name, but about things that obviously someone could link. Now you're going to be in a bit of a difficulty if there are only 3 or 4 people in the office, but there's no reason for someone to need to know someone's particular identity. I do think that it is possible that some employees might be interested in, or might be, okay with you providing their name. And that would be if they don't really remember who they were in touch with at given times. For example, if they don't remember that, just something where they were in for part of a day or something, and they know they saw a few people, and it was very close to the time when they were feeling ill or something. They know they saw people, but they can't remember. They may want, for those others' protection, to have you disclose their names so that others who would remember only if they had the name would know that they need to, quarantine for a while or be very careful. That might be the exception, but I mean, this is a disease that people are getting involuntarily. It is not uncommon. It is not as though it's some, something where they took a wrong step or there's anything to punish them for. So I think it's possible that people might want to help that way.
And let's be practical as well. If you've got an office with 5 people and one of those people has been out of work for a week and then they test positive, right? They've been out of work for 2 days and then they test positive, right? You as an employer are going to need to inform the rest that they've been in contact with someone who is now tested positive. When you have a conversation with the employee who tests positive, right? Yes, you shouldn't say, I'm going to disclose your identity to everyone else, but I think it's pretty obvious that everyone is going to understand who it was. And so you can have that conversation with the employee saying, look, we need to let people know that they've been in contact with someone who tested positive. It's going to be obvious that it's you. Do you have any problem with us saying that it's you? And if they don't ever, most likely they're not going to have a problem because everyone's going to figure it out, right? And so that's okay. And if they do have a problem, then look, when you tell your workforce that someone has tested positive, you say, look, I'm for privacy reasons, I can't confirm or deny the identity of the person, and that's it. And everyone's actually will know who it is and we'll figure it out. But at least you haven't sort of taken that affirmative step of doing anything more than what you should do as an employer to try and protect people.
We have a lot of questions coming in, and one that related to something you just said is there a specific format for an employee to give written permission for you to disclose, or any magic words or anything that you should include in that?
I'll answer that first, Josh, and you may have other things to say, but and if I'm wrong on the employer side that I don't think there's a specific form, there isn't for privacy purposes for an employer. There would be if it was a HIPAA covered entity, but I do think it's very important to have the, whatever it is, to have some indication that the employee is voluntarily providing this, and to make that pretty clear, that and maybe just use the words, I'm voluntarily disclosing and giving permission for you to disclose to others this condition. And the reason for that essentially is that it could be said later that the employee was somehow coerced into giving this consent, which is not it would be a rational thing for someone to argue. And just, not that we all want to learn privacy law, but just for point of information, the European privacy law, which is very, very protective of individuals, does not even recognize, they will not treat an employee's consent for disclosure of personal health information, disclosure or use, as valid, because they don't think it can be trusted, because it could have been coerced. And so an employer needs another basis for use and disclosure other than consent from the employee. And so it's an indication of how someone might be suspicious about an employee's consent. And therefore, I would suggest that there be language in there that they're essentially attesting to the voluntary nature of their consent.
I agree. It's best practice to get something in writing, and there's no magic form. I've put together several different versions of sort of consent forms or voluntary disclosure forms for companies, but there's nothing magic about it, as long as, I think, as Nancy's laid out, you make clear that this is something that the employee is voluntarily offering to do.
Okay. Very good. Well, one of our attendees has just asked if I said a few moments ago that no PEI member employee has been diagnosed. If I did say that, I didn't mean to. We're not aware of many, M-A-N-Y, not any, N-A-N-Y. We certainly have heard of a few cases. Here's a very specific question, and see if you guys want to take a crack at this one. Here's a company that says, we have approximately 70 employees. You talked earlier, Josh, I think it was, about temperature checks. So in this specific case, they have 70 employees, and the person says, should we be taking temperature checks or maybe use a pulse oximeter when they clock in as a preventative? 70 employee person company.
It's hard to give a prescriptive, yes or no. I think that a lot of it depends on both the nature of your business and, how many entrances you have. How does everyone tend to come in at the same time, or do you have waves of employees? Can you afford to have a dedicated health professional on site doing temperature checks, or is there someone who has the time and is qualified or has, can do that, who works for you already? And then do you want to do that? Because it's not required. It is allowed. It is a step that employers are taking to try to make sure that people who come into the building or the facility, don't have a fever, but obviously someone can develop a fever at any time. It's not a cure-all. So I would say that for companies that are not doing temperature checks, which is probably the majority of companies, I do recommend, I like to still have employees sign in with some kind of certification, whether that is an individual by individual certification or sort of a sign-in sheet, and that by signing, it certifies that you've been symptom-free, you haven't had a fever in 3 days, you do not currently have an elevated temperature, and you don't have a family member who's currently sick. That buys you a little bit of additional due diligence and protection. And I think that that is an acceptable alternative to temperature checks, which frankly are time-consuming and can be costly to a company.
Very good. Nancy, this might be a good question for you. It has to do not so much with confidentiality and privacy within the company as with customers. So can or should an employer disclose COVID-19 related health information to a customer when the employer is sending workers to that customer's location? And this would be very common in PEI world. There might be a job that a member would send 5 or 6 or 8 or 10 technicians out to work on a job site. Does the employer have the ability to share any information about COVID within their organization with that customer?
Well, I think that if it were discovered after that and that an employee had been on that customer's site and had tested positive, I think there would be an obligation, just as there is to your workforce, to inform the customer that an employee who was on the site tested positive and without identity, but just, this is a safety precaution. And those who were there, the customer needs to inform them that they need to, that they may have been exposed and they should take appropriate precautions, be extra careful about any kind of symptoms, et cetera. I don't think it would be appropriate. I certainly don't think it would be appropriate to disclose any individual identities or, probably would not be necessary to say that the 2 people who were working on this side of the site, that it was one of them. I think that would depend on the circumstances. If it was a very discrete area where the infected employee was working, maybe you'd want to be more specific, but that, essentially you're trying to give the information to allow the customer to protect its employees without revealing more than is necessary.
Very good. Here's what I think is a fascinating question. So you've already advised that in the workplace that you do regular and pretty deep cleanings of the office environment. One of our attendees has asked, if we are requiring our employees to work at home, do you recommend or do we have to offer paid professional cleaning of their home office or workspace? Isn't that interesting?
That would be nice.
It's certainly a nice perk.
Yeah, I can use it.
I've been doing a lot of deep cleaning of my home for the last 2 months. But no, I don't recommend it. It's certainly not required. I would say it's not something that I've heard of employers doing. And let me sort of follow up on that, which is, there are a lot of new burdens on employees who are teleworking, right? There are office supplies that you may need and that you don't have easy access to anymore because you're not coming into the office. You obviously need to have a computer. There are, this is taxing on everyone's internet connections, particularly if you've got multiple people working at home and if you've got children on top of that who are doing virtual learning. You're obviously using your own phone, your own equipment. So certainly there are new additional costs on employees, and it is a state-by-state question whether any of those expenses, new expenses, need to be reimbursed as business expenses by a company. And in general, I think the answer is no, unless there are specific new expenses that the employee wasn't already paying for. California has got, for any of you who are in California, California is one of the few states that requires all business expenses to be borne by the employer, whereas most of the rest of the country, employers can pass along business expenses to employees as long as it doesn't bring them below minimum wage. Cleaning your home office, I don't think that even in California, that's something that an employer would ever be on the hook for. But my point of raising all of this is that I am seeing some employers provide some additional perks or fringe benefits to employees who have been teleworking and will be continuing to telework. So, looking at and refreshing your telework policy. So companies that didn't previously reimburse for cell phones but require employees to use their own devices, are starting to look into whether there should be a monthly reimbursement for that because it's now being used primarily for business. But all that said, I wouldn't put cleaning of your home office into that category. If you want to do it, that's a nice perk, but definitely not necessary.
Here's a question I think is fascinating. The questioner says, I have a technician who is not sick, but says he is uncomfortable working now because he's afraid of catching the virus. As far as I know, he doesn't have any underlying medical issues. Do I have to let him stay home? Do I have to keep paying him? Or does he have an obligation to come in and be on the job?
That's definitely a Josh question. It's a tough one.
That's a real world, that is a real world question.
It's a great question. Let's sort of break it apart. And some of it will depend on particular circumstances. But the general answer is that an employee does not generally have any legal protection or job protection or right to leave because of a concern or a fear of catching COVID, or because they don't want to have to travel into the office and be in an office environment. This is assuming that your business can be open under state law or has been deemed an essential business. That employee may have paid leave in a PTO or vacation bank or a sick leave bank that they may be entitled to take. Once they use up that paid leave, they have most likely they do not have any rights under state paid leave law, under federal unpaid leave law, or under your own company policy. And so as a company, you can instruct that employee that, you could allow that employee to go on unpaid leave. That's a combination of a business decision. How critical is this employee? Do you need to fill their job? And what kind of message do you want to send to the workforce? Those fears may be reasonable and justified, even though you need them. And so you may want to send a message that we can deal with people taking unpaid leave. Frankly, some companies may be happy if employees want to take unpaid leave to get them off the payroll. Others may not be, but you don't have to. The employee doesn't have a disability, so they're not entitled to any kind of reasonable accommodation. They're not caring for a family member or themselves. They don't have a serious health condition, so they're not entitled to FMLA leave if you're big enough, or some form of state family leave. So, and for cities and states that have passed, including the federal government that have passed sort of paid emergency leave laws for COVID, this doesn't fall within one of those categories. So the short answer is you can also terminate that employee's employment if they refuse to come back to work and you need them. All of those options are kind of on the table, and you're going to need to evaluate what makes the most sense for your business and what kind of message you want to send.
Okay, as I said, I thought it was a really good real world question, and that is a really good real world answer, because there are so many variables that could come into play there depending on the individual case. Nancy, I think this would probably be a question for you. And it's sort of the opposite of what we've already talked about. We've talked about disclosure of your own employees' conditions and situation. What about the reverse side? As our members send workers to a customer's facility or job site, should they ask for any disclosures from the customer, either about their employees or about precautions that they are taking in this environment that the employees' workers are about to go into? What would you say to that?
I think they're perfectly entitled to ask about that, and to get details of what the site is doing and what it has done, whether there have been any cases. I think it's a perfectly appropriate question. They're not going to be asking for individual identities. I don't think that would be relevant, but just to know what's been happening. Have they had a deep clean? How long have people been working there since the pandemic started, et cetera.
Okay, very good. Here's another question that sort of flips the usual concern, I think. The questioner says, we currently have 2 people working in our main office room together. I take it that means a 3rd person is out on paid family leave. And I assume that that means related to COVID. Let's assume that for purpose of this question. She is planning to come back soon, but her 2 coworkers are concerned to have her in their environment. They also don't want to start wearing masks. What do we do?
Well, I guess there's 2 categories when the question that talks about paid family leave, and that could mean one of 2 things. If it means that the employee is out because they're caring for a child because that child's school has closed, there are sort of under the federal Families First Act, there were 2 categories of paid leave that employees are entitled to. The first is if that employee themselves gets sick, or if they're caring for a family member who is sick, or they have to quarantine themselves, or they're seeking a medical opinion. You get 2 weeks of paid sick leave. But there's also this category of paid family leave, and that's very limited. It's 12 weeks total, 10 of which are paid, but it's only to care for a child whose school has closed or whose child care provider has shut down. And so if the employee is out for paid family leave, there really shouldn't be any concern, health concerns, because that employee, it's not that that employee has had COVID, they've been caring for their kid. So that's sort of point 1. Point 2, if the employee's out because they've been sick, if they're allowed back and they've gotten authorization from their healthcare provider and they've now tested negative sufficiently, one hopes and one would expect that person is less of a risk than anyone else, because they're generally they're not positive, and they're now they no longer have symptoms. They shouldn't, they're not contagious according to the best understanding right now of the CDC and doctors. And frankly, they probably can't catch COVID for some period of time. They're hopefully immune. We would hope for a long time, but no one really has any idea at this stage. But we're not seeing major, big reports of people catching it multiple times seriously. So, realistically, there shouldn't be a concern on behalf of the other 2. Now, if the person's been out, I understand there being a concern that they haven't been out long enough, they haven't been symptom-free long enough, or they haven't tested negative, or that they could still be contagious. And obviously you want to allay those concerns. And certainly you as an employer want to make sure that the employee returning is qualified to return to work. But hopefully, there should be a way to alleviate people's concerns. The last part is the 2 people in the office don't want to start wearing masks. And the question is, what do you do? And that's a great question. Can you separate employees physically so that people are not on top of each other and are keeping, at least 6 to 10 feet apart at all times, and limiting cross exposure between everyone in the office? So that's one question. And 2, if they refuse to wear masks, my advice would be get that in writing. At least have something in writing that confirms that you've asked them to wear facial coverings, and that they have that they don't want to, that they've refused to do so. The purpose here, look, you've got kind of 2 goals as an employer, right? One is protect the health and safety of all of your workforce, and 2 is you want to take steps that you want to avoid someone making a claim against you later on that you acted recklessly or negligently in getting people infected, without taking a position one way or another on the validity of any of the lawsuits. You probably read about lawsuits against certain cruise lines or other businesses that had massive outbreaks, elderly care facilities that have had large outbreaks and that allegedly were negligent. And that's what you want to avoid. You don't want to be held liable for having an unsafe workplace. And so, asking people to wear facial coverings, great, and documenting if they refuse to, I think that should largely be sufficient. If you want to require them to wear facial coverings and they refuse, you've got fewer options there. It's sort of give in or send them home.
Okay, here's another mask question that sort of relates to that I think is interesting. If an employer requires masks to be worn in an office environment, is it the company's responsibility to provide those masks, first of all? And then second of all, if an employee wants to use his or her own mask, is that okay? Or is there risk in the employer not approving it, and checking it out to make sure that it's okay, that it's a good one?
That is a good question. I'll take the second part, and Nancy, please chime in. I don't think that an employer needs to check or approve the facial covering. I think as long as if employees want to bring their own in, that should be sufficient. We're not talking about medical grade masks here, and in fact, generally those aren't available to the public. In states that have, or counties like where I live in Maryland, where you are required to wear facial coverings if you go out in certain public settings like grocery stores. There's no prescription of exactly what kind of facial covering. Scarves are okay, bandanas, cloth masks, T-shirts that you've formed. There's a wide variety. And so I don't think you as an employer need to have sort of a pre-approved list. Whether you should be providing the masks or not to employees is an interesting question. It's one I talked about just yesterday with a client. And what we concluded was if employees start asking about it, it's something that management would think about, whether to provide a stipend to employees to purchase their own masks, or would try to find and source them, although it's not always so easy, depending on how large your workforce is, to source sufficient masks. I think the better approach is to have employees wear their own, because generally speaking, people have facial coverings in almost every city or state now. And if employees start complaining that they don't have them or they have to buy them, you can consider, funding that for employees. But I don't think that there's a legal obligation that you as an employer have to provide them. Although if you are requiring employees to wear them, I think it's a good idea to look into seeing if you can purchase them. Keep in mind also the best masks are generally washable and reusable, not disposable masks, which no company that I know of, or very few, are looking into buying 10,000 disposable masks to make available to employees. So if we're talking about rewearable, maybe each person needs 2 or 3 of them at most if they want to wash them regularly. So we're not talking huge costs here, and most employees have them already.
Here's a PTO question. We've talked a little bit about PTO in general. Another very practical, real life situation. So this individual asks, since their company is in a jurisdiction where working from home is mandated by the state. However, because of reduced workload and inefficiencies in working from home, the questioner is wondering, is it legal for me to mandate that they take PTO for that? In other words, rather than just saying, you have to work from home, I'm going to pay you exactly what you've been making from now on working from home, to instead say, hey, it's not as efficient as at home. Frankly, our workload is down, so I'm going to ask you to take some PTO. Is that acceptable?
So my general recommended approach here is to give employees the option of going on unpaid leave, furlough, or reduced work schedule with reduced pay, or using their PTO, as opposed to saying, you are going to be not out of work for the next 2 weeks, and you need to use all of your PTO. By giving employees the option, I mean, from your perspective, it doesn't really make a difference if they go on unpaid leave. You're saving yourself. It's the same cost to you in the end because the PTO is on the books, whether you pay them or not and draw down their bank or they're just unpaid during that week. But at least it gives the employee some decision-making or choice in the matter, and it doesn't feel like they're being forced to burn all of their vacation during this period of time. I mean, look, employers everywhere are facing these issues and are looking into reducing schedules, pay cuts across the board, furloughs, anything to try to avoid laying off employees. And generally speaking, employees understand and appreciate when companies are making efforts not to lay people off. And so these are some of the hard choices that you're facing. So I would go the route of giving employees the option. And I know it's a bit of a chicken way out of it. I didn't exactly answer your question of can you force them to. It's partly going to be dependent on what your policy says and what state you're in, but most likely you could force them, put them on quote paid on leave and require them to draw down their bank. But I don't recommend that as the only no choice.
Okay, sounds very good. All right, we are just about out of time. What I'd like to do is just in the last moment or two, sometimes I do this when I'm doing interviews for articles that we write. Is there anything else, Nancy or Josh, that we have not covered yet that you just have on your mind, you just really want to say before we get off the call? Anything that is essential, either from the privacy standpoint or the reopening for business standpoint that we've not covered yet that you guys just want to mention before we close? Josh or Nancy?
Well, I'll say one thing, which is not, I mean, I think we sort of have mentioned it, but I think and I think it's sort of implicit actually in Josh's response to the last question, which is, I think particularly in this circumstance where everyone in the world is aware of this crisis and what we're going through, that bringing your employees on your side or taking yourself to their side, so you're on the same side, is the best approach from a privacy perspective and from an employment law perspective and from a humanity perspective, is sharing the difficulty and working together with them on solutions, so that in the example I gave of when they might want to share their identity as being infected, that's something they might want to do for others' protection. It might make them feel like they're making a contribution, and likewise, any of these approaches, any of these issues, you absolutely want to keep in mind your own liability, but the way you approach it can be a way that actually reduces that, because your complaints are going to come from your employees under privacy law or employment law. And if they understand, first, what we first discussed, transparency in your guidelines and your procedures, it's you're sharing with them your approach, you're sharing with them the reasons for it. I just think that's all around a really important thing to keep in mind.
Fantastic, great point. Josh, any closing words?
I couldn't have said it better. I agree with Nancy completely. I think having a plan, communicating that plan and your approach to employees, and staying in communication with employees so that they know that you're on top of this, that you are taking this seriously, that, as Nancy said, you're on their side, that everyone's goal is to sort of survive and to get through this. And so, what you don't want is employees to feel that they're bearing the brunt of all of this, that they're making all the sacrifices, that they're taking pay cuts or having to put their health or safety at risk, and that the company is only looking at the bottom line. And I think all of that feeds into both, yes, what is our goal? It's, we want to stay in business. We want to continue to thrive. We want to keep everyone safe. We want to reduce liability risks, certainly, but that's not, the fundamental goal here. And I think the more you communicate with your employees, the better chance you will have that people aren't going to, try and come up with claims or bring claims against you. And obviously the better chance you'll have as well that everyone takes this seriously and practices social distancing and, tries to avoid an outbreak. So anyway, Nancy, I thought that's exactly the right, sort of overarching approach to this.
Terrific. Well, we are officially out of time now, and Josh and Nancy, can't thank you enough for sharing your expertise with PEI. We are so grateful for that. As a reminder to all of our attendees, we're posting the recording of this session on our website, and just as important, links to the 2 documents that I mentioned, the advisories that Nancy and Josh have been involved in writing for Arnold and Porter. We'll have links to those, and I encourage you to read them. They're terrific documents that go a lot deeper even than we could in this short call. So thanks to everyone for joining us. Have a great day and stay safe out there. Appreciate it.
Thank you.
Bye-bye.
Yeah, thank you so much, Rick and Melinda.